So, good evening, everyone. Thank you so much for being here tonight. Happy autumn. It's the first day of autumn, so it's a beautiful autumn. I, I, I hope you enjoyed last day of summer yesterday because it's beautiful. So here we go. It's my favorite season. So my name is Vanna Howard. I just want to thank some people. Want to thank the Lowell Pollard Memorial Library for providing the venue for tonight's talk. Want to thank the co-hosts, Solidarity Lowell, Indivisible Lowell, and Chelmsford Connected. So thank you for hosting, and thank you all for being here tonight. Now, I am delighted to be your MC tonight. Now, this is not the first time Dr. Forrant, this is the second time he did this talk on the 14th Amendment last month in August in Chelmsford at the Chelmsford Center for the Arts. And so tonight, thank you so much, Professor Forrant, or Dr. Forrant, I should say.
No, please. Bob.
Bob.
Thank you.
My mom would not be pleased if I call you by your first name, Bob. And so it's Dr. Forrant tonight. So we're honored to have you giving us your time tonight to talk on the 14th Amendment. And so if many of you here, I think all of you here, if not, Dr. Forrant is a UMass Lowell professor for 31 years. And you're not allowed to retire. I know you want to retire. You're not allowed. I don't think your students want you to retire. But 31 years teaching courses on global labor, teaching courses on labor history. He's a professor, a history professor at UMass Lowell for 31 years. And something I found out tonight about him, he's a really good cook. Ladies. He's a catch. He cooks everything, but he cooks all things Italian. Okay, who's Italian in this room? So, oh. Exchange phone number tonight. Oh. So going back to the 14th Amendment, and so it's very important. The question here is, and you're gonna take over, but with the conversation that's been going on in the last 8 months, right? The question is it legal? Is it legal to overturn the 14th Amendment? Because, as you know, the 14th Amendment was, under the Constitution, we would need Congress and the state government, right? 2/3 of Congress and at least, I think, 1 1/4 of the state government. And so you are gonna talk about that, about the 14th Amendment. Is it legal to do that without Congress and without our state government? And I am pleased to introduce you to Dr. Forrant to tell you more about the 14th Amendment.
So I did do this talk about a month ago, and so I decided to completely change it this time. So that I wouldn't be bored with what I was going to do. I didn't completely change it, but I changed it some from what I did before. And I need to figure out where to stand so I'm not standing in front of the visuals or you. How about over here? Is this good right here? I can't sit down while I'm talking. It doesn't work. So the 14th Amendment, the short answer, the easy answer is a president of the United States can't single-handedly change the Constitution. That's the short answer. The more problematic answer is that in some way what the president is trying to do is use the White House and use all of the communication tools at his disposal to build a case for a reinterpretation of the 14th Amendment. That's possible, and that's possible to be done by the Supreme Court of the United States. So it's not that, in the end of it all, it's not that he's trying to say he's going to get rid of the 14th Amendment. What he's doing, and hopefully I'll explain that, and we can deal with it in questions, what he's trying to do, again, is use various means at his disposal, the news, his social media, other people's social media, and everything that's happening as well is connected to this, everything that's happening with the deportations. All these things together are an attempt by him and by the people around him in the White House to get the Supreme Court, if this case ended up in front of them, to change the way the law is interpreted. And so that's important to know, because absolutely he cannot just say, I don't like the 14th Amendment, off with its head. Although everything else that's been happening lately, I would normally say to my students, that can't happen. And then it's happened. So all bets are off in an odd kind of a way. And so the way I want to frame this is that the way we think about immigration history and the way generally we're taught about immigration history is that this country has always been a welcoming place. It's always been a place where people who were different, who spoke different languages, ate different food, all of those things, right, that a lot of us have come to value in Lowell, that everybody was always welcome, and we were one big happy melting pot. People dived in and came out American, and everybody lived happily ever after. What I would say is none of that's true. We've gone through brief windows of time where that was the case, but more often than not, we've had a real sort of love-hate relationship with people, new people coming into the country. And a lot of immigration policy has been framed around the needs of the labor market, the needs of the workforce. When we've needed workers in abundance, we've basically let down the gates, welcomed people, recruited people, actually gone with ships and brought people over. And then on the other hand, when we don't need that labor anymore, we've sometimes violently, but usually quite aggressively, we've deported people. And so what's happening now, again, to have this in historical context, the way I think about immigration history, what's happening now is the third or fourth wave in American history of major deportations. And so again, hopefully I'll explain that tonight as we go as well. This is a very famous photo, which I really love. When I'm teaching immigration history, I love to start the semester with it and sort of say, when you look on the deck at the faces of all these people who are coming, it's a very aspirational photo. People have left a circumstance, in most cases, that they didn't want to leave. Most people who emigrate to the United States in the mid to late 19th century, early 20th century, are fleeing something very, very difficult. And people aren't coming on a whim. And so these are people on a boat that are this is just before docking, and they're going to get off of the ship onto smaller ships to be taken to Ellis Island. These big ocean cruisers couldn't dock at Ellis Island. The water wasn't deep enough. So you would end up getting off on a much smaller ship, off of this ship. And so people are waiting. They're probably, some of them, looking at the New York City skyline as it was in the early 20th century and being amazed at what they're seeing. And this is a quite hopeful situation. And so, birthright citizenship. This is enshrined in the 14th Amendment to the Constitution. Important to keep in mind. But what's also important to keep in mind is the concept of birthright citizenship was enshrined in law, constitutional law, Supreme Court rulings, Supreme Court cases, before the 14th Amendment was added to the Constitution. There were a series of Supreme Court cases of the United States earlier in the 19th century. And in each of those instances, the Supreme Court at the time affirmed the idea of birthright citizenship. It's important, again, because the way the Supreme Court works And I'm not an attorney, and I'm not going to pretend I am one, but from what I know as a historian, the way the Supreme Court works is it's theoretically supposed to go on. Precedent, prior law, prior rulings, and unless there's some glaring thing that's changed, you're not supposed to dramatically alter the fabric. We shall see. But at any rate, birthright citizenship enshrined in the 14th Amendment. This is what it says. All persons born or naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. It's pretty straightforward when you read it. It is what it is. Passes in the Senate 33-11, the House 133-36, and June 13th, 1866. That's the date that happens. July 9, 1868, 2 years later, 3/4 of the states have ratified the 14th Amendment. The 14th Amendment is added to the Constitution. So in order for any of the states that seceded from the Union, in order for any of the Confederate states to be admitted back into the Union when the Civil War is over, amongst the requirements is the ratification of the 14th Amendment. They cannot be let back into officially into the United States, have people in the House, have people in the Senate, vote for president, do all that cool stuff until they ratify the 13th, the 14th, and also eventually the 15th Amendment to the Constitution. No southern state, again, could be readmitted. So it's the law of the land. If we jump forward a little bit, so I'm going to go back and forth a bit, so bear with me. Again, the sort of duality of how we think about immigrants and immigration. This is a photograph that I really like as well. I like a lot of photographs of like crowds of immigrants. This is really amazing because if you look at it on both sides, those are blackboards. That's an English class going on in about 20 different languages outdoors at the Underwood typewriter factory. But what's fascinating again is that the need for labor, getting all these immigrant workers from all these different parts of the country, you're making typewriters and you're also simultaneously teaching the workers in your factory English, these blackboards, and I mean, it's just an amazing sort of photo, and the sort of, again, the duality where sometimes we're welcoming people, wanting people, and we're going to go bend over backwards to help them learn the language and assimilate in a way, and then on the other hand, like, let's get these people the hell out of here. This is this interesting moment. Similar kind of a context, Angel Island in California, the opposite. Angel Island in California is the place where people coming in as immigrants on the West Coast would go through. It's like it's the West Coast version of Ellis Island. And it largely was a jail. And people would be held because, as the slide indicates, starting in the 1880s and by 1917, there are several laws on the books keeping Asian immigrants out of the United States, barring them from ever achieving citizenship. And if people tried coming into the country, they would basically be held for a time at Angel Island, and in many cases simply deported. So sometimes people could get in, but they could never achieve citizenship. So in the 1880s, 1870s, we recruited thousands and thousands of Chinese immigrants to build a railroad, and to mine for gold and do construction of San Francisco and other cities up and down the West Coast. Once a lot of that work was done, we passed something called the Chinese Exclusion Act. So again, the duality here. So 1886, the Chinese Exclusion Act goes on the books, and essentially it says, and this is going to figure into the story here, so you have to hold this idea somewhere in your head as I move along. The Chinese Exclusion Act says you cannot become, you Chinese folks who are here, you can never become a naturalized citizen of the United States. Forget about it. Not going to happen. To double down on that idea, there's also at the same time a piece of legislation passed to not admit any Chinese women into the United States. The thinking being that if there are Chinese men here and there won't be any Chinese women here, the Chinese men will leave. Interesting thinking process here. I'm not sure how that always plays out, but that was the idea, at least, and again, in the heads of the people that were doing this. And so that's not my writing, that's the bill, the Asiatic Barred Zone. That's what it was called, essentially saying from that part of the world, nobody could enter the United States. Angel Island, this is an interesting quote. Somebody once said that Ellis Island was to let people in, Angel Island was to keep people out. The station enforced strict race-based immigration laws, including the Chinese Exclusion Act, that made it illegal for Chinese workers to come to America and for Chinese nationals already on U.S. soil to ever become citizens. So again, keep this in mind as we work our way forward. A little further along in the 20th century, this is a photograph of Mexicans and Mexican-American citizens being expelled from the country in the 1930s. Another wave of get out. So in the 1930s, and as the Great Depression hit, the slogan that was used in the US a lot was American jobs for Americans. Even though some of the people who were deported were citizens, were Mexican Americans, were citizens of the United States of America, and had been here generationally, probably back into the early 19th century. Most of the Southwest actually was Mexico's before we took it in a war. Basically, in these roundups, they didn't essentially care if somebody was a citizen or not a citizen. If you looked Mexican, you were rounded up. And in this case, people were put on trains. These are people waiting for a train. They're waving at a train. Obviously, their relatives are on the train. Most of us have heard of and know about this, but another example of rounding people up, citizen or not, and depriving people of life, liberty, and a pursuit of happiness. This is during World War II. This is the President of the United States by executive order. So a lot of immigration policy, a lot of bad things, at least that I think of as bad things in immigration policy, have been done by presidents by executive order. And it doesn't matter which party. In this case, this is a Democrat, Franklin Roosevelt, who for most liberals and people that grew up in working class households, as I did in the 50s and 60s, Franklin Roosevelt was like Jesus. He was the patron saint of the working class for many, many people. In my dining room as a kid growing up, there was Jesus, Kennedy, and Franklin Delano Roosevelt photographs in the dining room, like arrayed around a cross. And so when I first found out that Franklin Roosevelt was the author of this act that created Japanese internment, I wanted to burn my history books, but obviously I didn't do that. But again, rounding up people irrespective of whether you were a citizen or not, so Japanese immigrants and Japanese American citizens rounded up, essentially told to abandon their property, their homes, if they were in college, their education. If you had a farm, you had to leave it. And then you spent the next 3 years in what in the U.S. history books we call an internment camp, but it's probably more aptly called a concentration camp. At any rate, this is a family waiting for that deportation. Those tags are basically an identification of where they're going. It's a striking photograph. Dorothy Lang, the photographer, was hired by the federal government to take photographs of the internment process and the internment camp. She was an amazing photographer. And she took incredible amounts of photos of the internment camps with the one proviso that she was never supposed to take photographs of the barbed wire that was on the fences that surrounded the camps. And Dorothy Lang, being Dorothy Lang, she took pictures of the barbed wire intentionally. And this photo and hundreds of the photos she took were actually impounded by the federal government. And they didn't see the light of day until the 1970s, when somebody in an archive accidentally discovered the negatives. And so there's actually a book of her work called Impounded, which is a collection of the internment camp. of the internment camp photos. So, again, jumping along here and there, 1942, 1943, federal case, Reagan versus King. This is a lawsuit that's an attempt, again, interesting, to disenfranchise Japanese Americans. So people who are citizens, federal government decides basically they're going to sue the registrar of voters in San Francisco and order him to remove 90 Japanese American names from the voting rolls. These are citizens of the United States. The argument being it's wartime. And so somehow wartime means you can strip the citizenship away from people. This is the argument that the federal government is making. And again, Franklin Roosevelt's still the president while this is happening. This was denied at every level of the court, all the way through. It made it to the Supreme Court, and in May of 1943, the Supreme Court declined to hear the case, which in effect threw the case out. And it again, in its own way, it reaffirmed birthright citizenship, and it's saying, no, these folks are citizens. You can't take their voting rights away. This is the president's executive order. I'm not going to read it. It's so poorly written and constructed that it gives me a headache every time I try to read it, so I'm not going to. Suffice it to say, he's making the argument that the 14th Amendment only referred to, as he put it, the children of slaves and nobody else. That's his reading of the history. Hours after the executive order was signed, his first day in office, the American Civil Liberties Union and others with them filed a lawsuit against Donald Trump challenging Trump's executive order. Within days, other challenges follow. The case is blocked. There are what are called universal injunctions. This is where it's in the weeds, so I'll try to be as clear and get off it really quick again because I'm not a lawyer. But a universal injunction is something where at a lower court level, like let's say a federal judge in Boston, would say that what Trump is trying to do, what any president is trying to do is unconstitutional, and they would apply a universal injunction. And that would mean that all over the United States, everything related to that case would stop. Nothing could be implemented everywhere. What the Supreme Court said in this case was not that the president was right to want to get rid of birthright citizenship. What they agreed to was that a universal injunction was unconstitutional. And it's interesting because presidents have, from George Bush I, George Bush II, Obama, Biden, Trump in his first administration, have been in some way affected by a universal injunction. And each of the presidents, irregardless of party, has hated the idea of universal injunctions. But it became an easy way to try to stop something in court. And so what the justices did is interesting. I went back and actually read the legalese, and it gave me a splitting headache. But in essence, what they told the Civil Liberties Union and others is, look, if you want to go against what he's doing, file class action lawsuits, not a universal injunction. Class action lawsuits are the way to go. And so immediately after the court ruling, the court basically suggested these options. The president basically said after the Supreme Court, this was a huge victory. I said huge because that's how he talks, right? Huge victory that would permit him to end birthright citizenship immediately. So he didn't understand anything that the judges had said or anything about the Constitution. He also said, if you look at the end of the Civil War, the 1800s, it was a very turbulent time. If you take the end day, was it 1869? It was 1865, or whatever. But you take that exact day, that's when the case was filed, and the case ended shortly thereafter. This had to do with the babies of slaves, very obviously. So my editorial, nothing he said is true. All right. So the Supreme Court ruled, the ACLU, others filed class action lawsuits. There were several of them filed all over the country. The courts at all the levels working up to the Supreme Court, all the courts agreed to that children born of undocumented parents in the United States were a class in terms of a class action lawsuit, and granted the class action lawsuits and issued a stay on what the president was attempting to do. And July 10th, the federal court again blocked the executive order. That's pretty much where we now stand. The president could have appealed that ruling right then. The courts gave him 10 days to appeal it, and his administration did not appeal it. I tried to figure out or find out why, and I couldn't find anything. So right now, things are in a stalemate, I guess you could say. So now the history, as I was thinking about this. And this is the stuff I was reading about and researching for the last little while. So as early as 1824, so the idea of birthright citizenship has nothing to do with, per se, the question of slavery. The idea of birthright citizenship is in the founding of the United States. Birthright citizenship, the idea that anybody born here is a citizen, that's from the very start of the country. That was the accepted idea. The United States is one of about 30 countries in the world that have birthright citizenship. Most countries, especially in Europe, do not. In Europe, there's a process. If you're a kid and you're born in Italy, let's say, where your parents are not documented, you can become a citizen, but it can take, I think Italy's, you have to wait till you're 18. Other countries are different. Every country has a different process. Almost every country in Europe, none of them have birthright citizenship, unless both parents are citizens. In this case, in 1824, there's a young girl whose parents are Irish. They're Irish immigrants. They're not naturalized citizens. And they pass away, and there's a question of property and who gets property, and that goes to the courts, and the judge, Justice Story, says, quote, that the U.S.-born daughter of Irish subjects is a natural-born citizen of the United States, period. That's simple. Second case in 1844, the daughter of a daughter born in New York, again to Irish parents, is indeed a U.S. citizen, even though her parents returned to Ireland. So they returned to Ireland and left her here. Judge Louis Sanford wrote for the Supreme Court, by the law of the United States, every person born within the dominions and allegiance of the United States, whatever were the situation of his parents, is a natural-born citizen. So this concept of birthright citizenship, it's right there. This is 1824, 1844. There are other cases I could have added. There are several cases before the Civil War. The dilemma is that the Supreme Court in 1857 passes by 7-2 the infamous Dred Scott case, which says that black people cannot become citizens, just before the Civil War, by a 7-2 vote. Chief Justice Roger Taney argues black people, whether enslaved or free, were not and could not be citizens. To Taney, the founders had chosen not to extend citizenship to black people. That's how he interprets the Constitution. This is Dred and Harriet Scott. They lived in a free part of the United States for many years, came back to a part of the country that had slavery, and basically sued for their freedom. And that's why the case ended up working its way through the courts. So now we have this dilemma. Civil War ends 1865, not 1869, as the president said. Confederates in the South denied black people their basic political civil rights. As the war ends, to remedy the problem, Republican Congress passes not an amendment to the Constitution first. They pass a civil rights bill. in 1866. The Civil Rights Bill basically says, this is word for word, all persons born in the U.S. and not subject to any foreign power, excluding Indians, not taxed, are hereby declared to be citizens of the United States. And such citizens of every race and color shall have the same rights in every state and territory in the United States. President at the time is Andrew Johnson, a Southern Democrat. Abraham Lincoln, when he ran for president, for some reason, partly to try to figure out a way to unite the country, thought if he had a Democrat and somebody from the South as his vice president, it would be more magnanimous. It would be more like he was trying to bind the country together. And so when he's assassinated, we get a Southern Democrat as the president of the United States. President Johnson vetoes the Civil Rights Bill. So there we sit. 14th Amendment again. 14th Amendment is now put in place, ratified June 13th, passed by Congress June 13th, 1866. The Democratic Party opposed the 14th Amendment because they opposed black equality. They opposed, not all Democrats, but good many of them. Ohio, Oregon, and New Jersey ratified the amendment, but then after the 1868 election, when their state legislatures were taken over by Democrats, they basically renounced their ratification and took it back. This on the right-hand side is a picture of a ballot, Democratic ballot for Ohio, urging people to vote no and not ratify the 14th Amendment. Ohio eventually ratified it, withdrew the ratification. They did not re-ratify the 14th Amendment in Ohio until 2003. I don't know how they got away with that, but they did not re-ratify. That's really weird, right? Because we're saying to southern states, you can't come back in the Union unless you ratify. So I was actually thinking whether we could have Trump be declared not the victor because Trump won Ohio, but Ohio shouldn't be in the Union. So the vote shouldn't count. I don't think that would work, but I thought it would like stir up some crap. So in 1871, so the law is now on the books. In 1871, Secretary of State Hamilton Fish, commenting on the 14th Amendment. 14th Amendment is simply an affirmance, of the common law of England and of this country, so far as it asserts the status of citizenship to be fixed by the place of nativity, irrespective of parentage. The qualification, quote, and subject to the jurisdiction thereof, was probably intended to exclude the children of foreign ministers. And basically it was. The intent was that if you were working at an embassy in Washington, D.C., and you were from France and your children were born here, they were French. They did not. And so that was the exclusion. The exclusion was essentially if you were the children born here of foreign diplomats. Because technically, you see all these crime shows where a foreign diplomat kills somebody and then says, well, I have immunity. Like, I'm not subject to your laws. Basically, that's what that is. But otherwise, I mean, think about it, right? If the interpretation that the president now is trying to get us to buy is that undocumented people who are here aren't subject, he would have to argue that they're not subject to our laws, which would mean you can't arrest them for doing anything because they're not subject to your laws. Like, make up your mind, dude. Everybody follow? It's like, it makes no sense, right? But at any rate, further affirmation. Then comes this case that basically sets the bar really, really high for this question of birthright citizenship. So starting in 1880, there's a serious campaign in the United States on the West Coast to physically, violently push the Chinese out of the United States, to drive them out, literally and figuratively, burn down their communities, loot their businesses, kill their livestock, kill them. There's basically an attack on the entirety of the Chinese community on the West Coast. Many, many people leave, go back to China. Other people try to stand up, use the American courts, push back against what's happening. Other people go to South America. Many Chinese flee the West Coast and go to Cuba. That story never made sense to me until once I was visiting friends in New York City, and they took me to a Cuban Chinese restaurant. And I said, I don't get this fusion. And they told me the story, which I had not known. And they said, yeah, oh yeah. There's like a whole Chinese community in Cuba, and they explained to me, it was like, I think I was probably like 23 and dumb. Now I'm not gonna tell you how old, but I'm dumb. And so anyway, this is working. This violence is working. The federal government restricts immigration. I already spoke about that. I'm gonna rip through these slides here. And basically stopped immigration virtually entirely. In 1887, only 10 Chinese people entered the United States. So Congress is gonna now flip the switch again. 1930s, round people up, get them the hell out of here. 1941, 1942, we're in the midst of World War II. Millions of people are in uniform, millions more people are working in war-related industries. Nobody's working the land, we need Mexicans, come on down. And we negotiate a program with the Mexican government called the Bracero program, which is going to admit over the course of the program, nearly 5 million people. So push, pull, push, pull, push, pull, through the first 4 decades of the 20th century. If you came through the Bracero program, you were supposed to have a card like that on you at all times. The interesting thing is the little line there, 1-year contract, 75% of the prevailing wage. I mean, it was blatant. Yes, you can come, but we're not going to pay you what we pay American workers. You can get 3/4 of what they get, and you should be happy. And the reality of it was that many Mexican people wanted to come because it was still better. But it basically also set up this incredible dual labor market in the United States. Some people being paid less. It created real divisiveness within the working class in the US, which could easily be exploited by employers. And so not a good situation. This is a book that's just coming out the first week in October. It's the first time a scholar has actually tried to dig into and look at women in this process. Usually it's farm workers, and they're usually the way the stories are written focused largely on men. I have my copy on order, so I can't wait to learn something new. But in the book, she does talk about between 1921 and 1944, ethnic Mexicans scapegoated for the economic ills of the nation. Social workers, immigrant officers, and government officials on both sides of the border orchestrated mass removals that largely banished working class US citizens, wives, and children of Mexican immigrant men. And so she's writing about that. So if you rounded up a family, if you were going to deport the dad, the mom and the kids, more often than not, her research has shown went as well. And so in effect, what you did is deport a family, right? Now, the federal government could say, no, that's not what we did, but in effect, that's what she found in the research. So I'm eager to read the book. After the Second World War, now we have all these folks that have come in. We got to push a bunch of them out. This is the Immigration and Naturalization Services, their language. The alarming, ever-increasing flood tide of undocumented migrants from Mexico constituted an invasion of the United States. Where have we heard that before? Mexicans are now going to be rounded up and put on ships. Scholarly research, basically, this is a quote from one of the books I've used. A congressional investigation compared the conditions on the ships people were deported onto an 18th century slave ship. Deportation starting in June of 1954. The president at that time is Dwight Eisenhower, World War II war hero, one of the leaders of D-Day. And again, direct attack, their words, upon the hordes of aliens to discourage re-entry. Many of those apprehended were moved far into the interior of Mexico by train and ship. So what they did is they basically dropped people off in the middle of the desert. In one researched instance in this book, Impossible Subjects, 88 people died of sunstroke after being dropped off in the desert in 112-degree temperatures with no water. So this is the history. So this history as an oral history and as a researched and scholarly history in Mexico, this is what people are, this is the history people know. This is not necessarily the history that we know. And again, this is, Mexican labor leader reported that people were, quote, brought into Mexico like cows on trucks and unloaded 15 miles down the highway from the border in the desert. So the inhumanity, so what we're seeing now is this recycled. What's happening now isn't new, right? It's new to us in terms of us because of our ages. We weren't around, most of us. If I was around then, but I was 7. So I didn't know this was happening. All right, push forward a couple more and then I'm done. Supreme Court, again, has to take up this question of citizenship. A case works its way through the court with respect to whether undocumented children have rights to education under the 14th Amendment. Case works its way through the Supreme Court. 1982, Supreme Court observed there's no, quote, plausible distinction between documented and undocumented immigrants regarding jurisdiction, as both are, quote, subject to the full range of obligations imposed by the location's civil and criminal laws. Again, the point in the 14th Amendment, right? By denying these children a basic education, we deny them the abilities to live within the structure of our civic institutions and foreclose any realistic possibilities that they'll contribute in even the smallest way to the progress of our nation. I love the book title, No Undocumented Child Left Behind. Great play on the No Child Left Behind. So, all right, quick review. Just by basic case law, these are all the cases I've mentioned this evening. Every single one of these cases upheld birthright citizenship. The concept, the idea, if you're born here, you're a citizen. None of these cases, and I couldn't find, I Google searched and did all kinds of things about, did anybody say the other way? Are there any cases where they rule differently? No, couldn't find anything. Doesn't mean it doesn't exist, but if it doesn't exist, that means that my search engines stink. But at any rate, whole series of cases. I could have added 4 or 5 more. The president's executive order ignores a 127-year-old Supreme Court precedent that makes clear the guarantee applies to the children of non-citizens. July 10, a federal court blocked the executive order. Again, the president, as I said before, had 10 days to appeal, and he didn't. As of September 22, 2025, things can change. That's why I said as of September 22. No president can unilaterally decide who's a citizen. Supreme Court would have to reinterpret the 14th Amendment and go against seemingly settled law from before the Civil War, or the Constitution could be amended, which requires 2/3 of the members of Congress and 3/4 of the state legislatures to approve amending the Constitution. Thank you.